With the express request for brevity, the content of your assessment has also been included so that we can move forward with the session.
With your permission, Presiding Judge, members of the panel, it is also an honor for me to appear before the High Court and to be able to
defend a position that will certainly have to be considered by this court as well, not because it is new, since it is something that is already well established in jurisprudence,
but perhaps because of the context in which this case arises. I also thank the Honorable Chief Anti-Corruption Prosecutor for leaving the door open, even though he did not do so formally in his assessment, to adjust the sentence to the arguments of the popular prosecution and also to the position this defense will now advance. This defense, on November 21st, 2024, and being in pretrial detention in another case, not for this one in which he was at liberty, Mr. Víctor Aldama decided to start cooperating with the justice system.
That is always a very significant decision,
because it implies, first of all, giving up your own defense. It implies self-incrimination, let's say, without even playing the game at the preliminary stage of the investigation, and a surrender to their mercy. Como se habrá podido demostrar en este juicio, tanto en la parte fáctica y en la parte jurídica. Eso requiere un premio.
It requires a reward.
One of the defenses this side could have raised has been removed, it has been eliminated in this process, and it has even contributed to strengthening the arguments of the prosecution. There certainly was no plea agreement. There was no written plea agreement. Could there have been?
Could it have been done?
It is customary to do so in cases of this seriousness and in cases of even greater seriousness. We could have signed it and we would have had the guarantee of this defense. We would have secured the sentence that I am now demanding from the court. And external influences would have been avoided. It would have been a purely legal procedural matter. And maybe these submissions would likely already be over because we could have entered into a plea agreement based on the cooperation provided for in the law. It's not something handed out for free. It's no joke for the prosecutor's office, for any member of the prosecutor's office.
It's something that's provided for in the law, and the law provides for it in streamlined criminal proceedings. And it's provided for, as in this case, for crimes subject to this scope of prosecution, in which, according to the classification of the public prosecutor's office,
and if applicable, the sentence we might have agreed upon, this court would even feel bound by it. Because obviously the sentence sought by the private prosecution and also by this party is within the legal framework.
The abstract legal framework is intended to determine the severity of the sentences, the seriousness of the act.
But then the legislator considers special mitigating circumstances to adjust the sentence to the seriousness of the culpability. Some circumstances refer to the act, others refer specifically to the perpetrator. Some have to do with circumstances prior to the trial or concurrent with the act, others reward certain post-crime behaviors.
And przypomnę kamieli tezena, kana mazlunter analyst ketlkem sota, damit svidin pelvastor ulukostera tasen, parla kozen kalba, imutzei tarcenda bil pesmini ma ezlo, heta ana seipne, negrat, tena masena ne tertomebit en upetun perspekuten, nana tazen, put chemalkuchu, nalani tentatenis.
Case law has also recognized the possibility of mitigating circumstances in privileged criminal offenses, such as Article 574. Or even by analogy, if it were considered that one of the requirements for this mitigated offense was missing.
Is specifically analogy with mitigating circumstances that are specifically defined in the special part.
I have acknowledged the facts. We have acknowledged the facts as stated in the indictment by the public prosecutor.
And we have acknowledged belonging to an organization.
Yes, we are going to clarify the issue regarding the organization. And it was this party that brought it forward at the end of the trial This conversation from April 9, 2019, which I seriously believe has contributed to reaffirming the pillars of the accusation. And not only that, but they also reaffirmed the specific truthfulness of each of the events that Mr. de Aldama has described. This conversation is included in a report that has certainly also been confirmed. The report from June 5, 2025 regarding the public works. It's true that the procurement process is not what's on trial here right now. It's very important for the court to consider the effects of Mr. de Aldama's cooperation, as there is still a long judicial process ahead.
We actually agree with the prosecution. We are dealing with a case of corruption that involves high-ranking government officials.
This is a unique case. That's why I said that this court will have the opportunity to rule on it. We're not dealing with cases of drug trafficking or terrorism, the usual situations where this issue comes up. I certainly agree with the seriousness of the issues, the seriousness of widespread corruption, not just at a local level, not even at a regional level, but in the government of Spain.
And that it is necessary to restore trust in the institutions.
And precisely because of that, the conduct of a citizen who chooses to cooperate with the justice system is especially significant, because they are fighting against the state apparatus. In undertaking this crusade,
on November 21st, 2024, Mr. Aldama
knows that he is taking on a difficult role, not only because of the admission of serious crimes, but precisely because of the fight against the state apparatus. I'm going to try to move forward with this idea, but it does matter to me. It should be noted that the UCO report 96/2025 dated June 5 includes a conversation whose recording he is requesting be played. This part is very important for defining the organization. And here we are going to contradict the UCO when they talk about a certain hierarchy, or who is the boss or not the boss. Mr. Aldama does not constitute the criminal organization. Mr. Aldama joins a criminal organization that has already been operating since at least 2015. He is not the boss, he is the one who establishes a relationship with high-ranking state officials who were already corrupt. He does not corrupt them.
Report 512 from June of the year 2025.
On page 236 UCO investigation, it's already a report from the year 2025. Keep in mind that Mr. Aldama's first cooperation statement is from November 21, 2024, in which many of the facts that are later included in this report are provided, that had come up in the process because most of the facts that explain the criminal organization were not being investigated. The management solutions contract by itself, when considered on its own, was not serious. Mr. Aldama had been authorized to travel abroad. It was being discussed whether, in Mr. Aldama's case, the awarding of the contract could amount to influence peddling. Also, whether the profit obtained by virtue of the awarding of this contract could be exempt from taxation, or if it could be seized as a result of an influence peddling offense. In other words, there was nothing here until the facts came to light with the statement of Mr. Aldama, who, while in prison for another case, decided to cooperate with the justice system. And to reveal and assess the organization that is being accused today. That scope is later reflected in the UCO report, which talks about an organization, a pre-ministerial structure. Going back to the beginnings in 2015, ministerial during the time when Mr. Ábalos was minister, or even post-ministerial. That is, when we are told that Mr. Ábalos' sphere of influence remains even after he leaves office. But I do want to highlight how on page 286, and this contrasts with what Mr. Ábalos said, possibly because he had been told or had considered that this could be about management solutions.
Look, page 286 of this report, when it talks about that structure and the one from the ministerial stage, it mentions Mr. Aldama for the first time and how he was contacted in the summer of 2018. And it literally says, and I want to emphasize this, and I think this is a good headline, at that moment, the criminal organization is fully established. This is what the UCO says. Huh? The criminal organization is fully established before Mr. Aldama comes into the picture.
So Mr. Aldama does not form or create it. He joins an organization that already had the purpose of committing crimes, not any other goals.
That's why in this audio,
which the defense requested be played, it was important to see how it was already an organization that was dividing up public works. That was dividing up public works, for example, since 2015 when Mr. Santos Zerdan was already involved. The relationships that Mr. Santos Zerdan established with Mr. Koldo Garcia. When Mr. Aldama is first met, it's not that Mr. Aldama sought someone out or offered something and managed to bend a public official's will. No, it's the public official who seeks out a tool. Just as he already had others in the Basque Country and in Andalusia. There were other Aldamas, as we have stated, there were other businessmen.
but a new tool was needed for certain regions and to expand opportunities for contact with companies that were willing to pay commissions, either for personal profit of the high-ranking officials or for the Spanish Socialist Workers' Party.
When Mr. Aldama gives his first statement on November 21, 2024, there is an immediate reaction from the government. That's why I'm going to describe the government's reactions to Mr. Aldama's cooperation, because this is what shows the importance or significance and why his contribution should be especially valued.
Just 3 days after giving this statement, a petition for conciliation is filed by the Spanish Socialist Workers' Party, signed by Mr. Pedro Sánchez Pérez Castejón,
By Ms. María Jesús Montero,
by Mr. Carlos Moreno Medina, by Mr. Angel Victor Torres Perez,
by Mr. Salvador Ila Roca, Mr. Santos Cerdán León, and Ms. Begoña Gómez Fernández. Mr. Santos Cerdán León has the nerve to file or try to file a criminal complaint against Mr. Aldama because the material seized during the search, including Mr. Cordoba's mobile phone, had not yet been examined. Mr. Aldama gives his statement on November 21, 2024. The UCO is not aware of the audio we listened to the other day. It is opened in May 2025 when a first report on public works is issued. And Mr. Aldama had already said for the first time, hey, take a look at the so-called Basque quota. Now, Navarro, according to that. But pay attention, because Mr. Santos Cerdán has something to do with all this. And Mr. Santos Cerdán, 3 days later, files a conciliation petition. Of course, he didn't know what was coming next, because it has been proven we are constantly told by the government and provide evidence. Look, read, listen, read the entire transcript from the other day that was presented here to see the evidence that supports what Mr. Aldama was saying. As early as November 21st, 2024, by the way, we have also respected Mr. Avalos's privacy. We stopped the recording right at the moment when his relationships with young ladies were being discussed, which of course is of no interest to this party. When Mr. Aldama gives his statement before the investigating judge, the honorable judge, on December 16, 2024, immediately the Socialist Party requests that authorization be granted to proceed against Mr. Aldama. And it was said that Mr. Avalos, Mr. Koldo Garcia, Mr. Santos Cerdán, and Mr. Torres had been insulted. The fate of Mr. Avalos and Mr. Koldo Garcia is already known.
The fate of Mr. Santos Cerdán is also known, and soon in the special proceeding, the fate of Mr. Torres and Miss Armengol will be known.
That statement also led to the opening of a PSOE financing case, another of the complainants, and another group that is requesting authorization to proceed against Mr. Aldama.
It will also be determined in all these proceedings that started from Mr. Aldama's statement. Relevant information has been provided. This has made it possible to start some lines of investigation.
Of course, the UCO already had some information. We'll see that very briefly later. The UCO can provide objective evidence which already existed.
but to reach the level of certainty that this court requires to convict. The testimony of Mr. Victor de Aldama has been fundamental.
Because he has put the pieces of information together.
He has given internal coherence to the entire account that is included. Thank you. Thank you for the prosecution's briefs. A new reaction from the government even took place after the statement was given here on April 29th, 2026. The next day, Mr. Felix Bolaños files a civil lawsuit against Mr. Aldama. He didn't even wait for the trial to end. That has its own interpretation, just as the fact that the PSOE requested the imprisonment of Mr. Aldama in the case that is ongoing in Central Court number 5 does. Or also the fact that today, precisely an association linked to the Socialist Party is trying to distance itself from the unified private prosecution has its own interpretation. All of this has a sense of being a reprisal for a procedural action and is meant to discourage Mr. Aldama from the cooperation he has already provided and, God willing, will continue to provide. Thank you. We have acknowledged the facts. We have waived the defense contesting the charges. We believe, we have supported the prosecution in line with these objectives so that cooperation with the judicial authorities is recognized. The Public Prosecution Service, in Section 9 of their indictment, faithfully acknowledges everything that has been provided by this party, including how the new facts have been taken into account for the formulation of the provisional conclusions. And it has been precisely Mr. Aldama's account and contribution throughout these almost 2 years to assemble and put into context the real facts that are being judged here. The organization, as I was saying, cannot be broken up. Is it true that the formation of separate cases might prevent this? It prevents this court from having a global perspective, but it comes down to one of two things. Do we admit that Mr. Aldama's cooperation is comprehensive? And that's why when we assess his contribution, do we value it? Total conjunto, o si es que decidimos fraccionar el hecho, no sé hasta qué punto la organización. The importance that is really said to have, it's a difficult situation. What I believe is that it should be in this process where the criminal organization is rewarded as it should be, because otherwise a criminal organization could not be prosecuted. The criminal organization doesn't make sense if other facts different from those specifically contained here are not considered, and that's what this side has tried to demonstrate in the process. Thank you. The beginning of Mr. Aldama's relationships with other government officials, I believe, has been perfectly proven. I insist he joins an already established organization. I believe the central figure that is proven is Mr. Koldo Garcia, who had served as a key figure not only for the Ministry of Transport. Mr. Koldo Garcia. According to that report, that organization, which was already operating, is the key for Mr. Aldama's access to other ministries, his relationships with many chiefs of staff, his relationships with presidents of autonomous communities, and his relationships with presidents of other institutions and public companies. So that organization is not just a three-person vertical structure, as is being argued here. It is cross-cutting and horizontal. Mr. Aldama is an instrument, but not of Mr. Avalos. He is an instrument for something much bigger, precisely to satisfy the purposes of the structure that was already created beforehand. In those recordings, in that report, there is already talk about the involvement of other high-ranking officials, Ms. Isabel Pardo de Vera and Mr. Javier Herrero. That is to say, as I mentioned, you can't assess Mr. Aldama's contribution in isolation. The trips to Oaxaca and Mexico. I'll go over this situation very quickly. The international relations with Mr. Juan Guaido. He is even given a credential to serve as a contact with Mr. Guaido. It's not just about international relations. Mr. Guaido was one of the means used to obtain funding. I'm not going to mention anything that should be discussed in another proceeding, which is also confidential. That audio clearly shows not only the level of connections that Mr. Aldama has, certainly that created a sense of trust, it perhaps opened the eyes of Mr. Avalos and Mr. Koldo, prompting them to attack him. It's not that Mr. Aldama is attacking a minister, no, it's the minister who finds out through Mr. Koldo. that Mr. Aldama is interesting. He sees the opportunity to recruit him, to bring him into the organization, and he is recruited. And indeed, he allows himself to be recruited because he was certainly someone who could provide business opportunities. And from the ministry, they provided them to him, and he provided them, and in the end, they were shared. An example, Complejo de la Velázquez, already in November 2018, what does Mr. Aldama do? He makes an offer of 250 million for the acquisition of some properties from CEPI. And who supports him in that? Who gives him that business opportunity in the first place? And why are the doors open for him? Why does he have conversations there and meet with Mr. Vicente Cervera? In other words, who is Mr. Aldama? Well, he's someone with whom a business relationship was already established back in November 2018. But no, it's not, because Mr. Aldama has a special talent for corrupting a minister in record time. It's that they were already corrupt. I insist Mr. Aldama was brought in. The organization brought Mr. Aldama in. He was of interest. And he was of interest because of his connections with Mr. Henry Ramos Ayub. He had an important role in the Socialist International. And he was also brought in because they knew he had ties to Venezuela. Connections that are clearly proven in this audio. They take advantage of his connections with Guaidó, so he is given credentials from the Spanish government to serve as a contact for Mr. Guaidó, Aldama. Mr. Guaidó acknowledges it and is satisfied with being recognized by the Spanish government as president. A letter issued by Mr. José Luis Ábalos is sent, and Mr. Aldama delivers it on July 26, and it says, Your Excellency, Mr. Juan Guaidó, President of the Bolivarian Republic of Venezuela. Shortly after, the person who was president came to be called the head of the opposition, but the important thing is that this conversation has grown. It confirms what Mr. Aldama has said here. A business relationship is established. An oil business is established with two companies controlled by Guaidó. This was going to generate a substantial compensation not only for Mr. Aldama, but also for the minister. Just listening to the audio is enough to know what the expectation was. 500,000 euros every month for a period of 3 years. The relationships went further. I'll be brief. A trip to Georgia was organized. The trip of Delcy Rodriguez. When the position changes, when Guaidó is replaced by Maduro, how does that oil business relationship change hands? I won't go into much more detail. We're all with the goal of generating funds in any way possible. Other trips to Georgia. Trip to St. Petersburg. That is a variety of trips of an official nature, in which Mr. Aldama always appears in some way in organizing them. About the payment of commissions to Mr. Ábalos and Koldo, it has been absolutely proven. I refer to that, nothing more. Very well explained by the prosecution. Within the roles assumed, Mr. Aldama was certainly the person responsible for providing funds to that organization. Thank you. And he did it in several ways. Raising funds from companies contracted by the Ministry of Transport. Public Works contracting, as we heard in the audio, you can hear them say, we have to give a certain Public Works contract to this person or that person, and we have to talk to Víctor, because Víctor is the person who knocks on the doors of these companies to tell them, hey, if you want a Public Works contract, you're going to have to pay a commission. Or even to those who have already been awarded contracts, hey, if you've already been awarded, if you want more, you have to pay a commission. It was a fundraiser collecting funds delivered to Mr. Koldo and Mr. Ábalos, either for themselves or for the party. Mr. Aldama explained here, and that will be clarified in another case, that several of those funds would be used to finance the Socialist Party. Through a system of donations made in individual donors' names, but Mr. Koldo Garcia would take care of finding the donors, even if there were many, in order to raise funds for the party. A media outlet which we certainly have to thank, because we haven't been alone in this, in these statements, but also in statements by Mr. Aldama. They have later been corroborated and complemented by investigative journalism. El Debate published how donations to the Socialist Party had increased significantly in the year 2000
The raising funds from contractor companies will be one of the ways to get funds. Another is with Mr. Aldama's own funds. And here are the recurring periodic payments from October 2019 until 2022. Payments in kind were also provided to the purchase of properties or the use of properties. And here are properties, of course, such as Torre Madrid, La Alcaidesa, and Villa Parra. The Torre Madrid case is very significant because of the date. That is, as early as March. In March of 2019, which shows that this relationship of interest, that cultivation, happened just a few months ago, and Mr. Aldama is already starting to pay. And why does he pay? In the April 9th conversation, you can see how Koldo tells Mr. Avalos that they need to give something to Víctor because he's doing a lot of things and hasn't been given anything yet. Because the only thing he has to do is pay, not receive. They even offer him 200,000 euros. But Mr. Aldama puts in money. I mean, he starts paying because he was interested in promoting that organization, and he does it right away. We have explained perfectly, and I think complemented the evidence that had been presented here regarding the whole Torre Madrid issue. Why do they pay from the beginning, and how long do they continue? Because at a certain point it breaks off. There's a fight with Mr. Koldo Garcia, and I mean, he has given a very detailed explanation. It must be acknowledged that Mr. Escolano is one of the few witnesses who have testified here who are under investigation. He has given a statement, and he did so because this party requested it, and he did it because he is Mr. Aldama's partner, and we needed him precisely to corroborate that situation. I believe that is the situation. I think it has been very clear there is no need to assess his testimony, and I believe that the evidence, I will hardly refer to it because I think it is so obvious that there is little more this party could add. What matters to me is to place it in chronological context. In March, payments for Torre Madrid begin, and in that conversation on April 9, when they are already talking about Guaido's business, you have to see how Mr. Avalos says to Koldo at a certain moment, yes, but we have to sign a contract, as if saying, let's make sure that these deals being offered to us, certainly that we have to give something, but let's sign a contract to guarantee it. Mr. Aldama provides a contract to guarantee not only this issue with Guaido, but everything that had already been agreed upon regarding commissions and the awarding of public works. And that's where the contract for Paseo de la Castellana on April 24 makes sense, which is where Mr. Aldama lives. It's his house. This contract was provided by this party for the first time. The investigation was not aware of it. It was very important to prove with that contract what we were saying and how it was established, giving bribes and commissions. It is said, of course, there was a certain delay because the businessmen took a while to get paid by the ministry, and so it took them some time to get liquidity. And Mr. Avalos, as you can see in that conversation, was already demanding contracts that would somehow reflect the commission agreement. Logically, it wasn't a contract for commission payments, but rather indirect contracts that would somehow guarantee the receipt of those commissions. And the Castellana contract arose in that context. There was never any intention to acquire Castellana. It was certainly a guarantee contract in case Mr. Aldama did not fulfill his obligations, if he collected from contractors who had been awarded public works and then did not distribute the money. It was, in some way, a form of protection to say, well, at least I have the option to keep a property at a low price, which he never paid for, and there was never any interest in paying for, but rather they wanted to gradually pay those rents to disguise the receipt of commissions so that in the end they could acquire a property. A full explanation of this contract has been given. This contract is simultaneous. Gania at the same time has the option to buy Castellana, has the option to buy La Alcaidesa, with both contracts overlapping for at least 2 or 3 years. The payment for Torre de Madrid in addition to the house where Mr. Avalos was living. This number of properties obviously cannot be reasonably explained. The issue of La Alcaidesa is perfectly explained. In our defense brief, we already anticipated this, and in Mr. Aldama's trial, it was explained why it was assigned, indeed, to another company that happened to be there, because it had an interest in the ministry. And when the Venezuelan one fails, for the reasons that were also explained, well, it is decided that the company that should take over is Habcock Time. It's true that maybe some mistake was made regarding who should have obtained the license, in whose favor, because Habcock Time started operating in January. But in response to the document that has been submitted, we've sometimes had to defend ourselves against accusations from the defense itself about how Babcock time could be involved if Gaslow wasn't charged. The case against Gaslow began in 2021.
Well, look, what proves the truth is what Mr. Aldama might have heard about the reasons why a license was being requested in favor of a new company, such as Villafuel.
Report 164/2025 on hydrocarbons on page 12 states that there is a supplier which is not Galgo Time, but rather Keep It Safe. Maybe there was some misunderstanding at that time. It's a company that was part of the Gaslow Group, which was dissolved at the end of 2020. And how, at the end of 2020, a corporate restructuring took place around a new operator, precisely because the organization under investigation, which was later linked to a case in 2021, broke up at the end of 2020. What Mr. Aldama recounted is what he heard. He did hear it. That there was a problem with a group that had been operating until then, and that the license had to be requested in favor of Villafuel. This is the truth.
Whether it's Babcock Time, Keep It Safe, or whatever it may be, when these are companies that the UCO has ultimately linked to the Gaslow case.
The Valencia location was discussed. It hasn't been addressed in the prosecution briefs, but after all, the payment to a new operator was also proven.
The Commission, on the occasion of the acquisition of the Valencia location, and a payment of 20,000 euros.
Regarding the table of amounts on page 160 of the UCO 211/2024 report, the house in Humilladero was also presented as a new fact.
There had been no mention. It was not known that when this note referred to the big one was not Mr. Koldo. The big one was Mr. Abalos.
And that Goblins and Mr. Koldo. This proves, for example, how it has contributed to the truth. They have even corrected conclusions from the UCO. By whom? By the one who can make an authentic interpretation of the documents and messages. And this has been Mr. Aldama. It was mentioned for the first time that what Koldo Garcia wanted was for them to buy from Aldama the house he lived in, which Mr. Abalos had rented. Paying those 500,000 in that chart, when 500,000 appears, it means 500,000 euros. Aldama says, I have to pay 500,000 euros because I have to buy the house in Humilladero from Koldo, and besides, Mr. Abalos is asking me for 2 million for the mask issue. We have already said, and it is already included in the indictments, that this was about setting up a pool of funds to use that to effectively distribute and maintain that reciprocal economic interest among all of them. More apartments have been paid for. The reservation at Atocha 25. We've had to hear here in the end that Mr. Aldama apparently pressured Miss Jessica Rodriguez. It's unbelievable. The apartment, the media have also helped us with this issue.
Reports have been published about what was happening in the Atocha 25 apartment. Of course, it has nothing to do with Mr. Aldama.
If he has paid for it on some occasion, as he has admitted, just like he paid for the Ayala apartment, like he paid for the Oquendo house, so that she could stay where Mr. Rodriguez was, etc. Public Works and Construction. Dicho lo que teníamos que decir, la importancia de la contribución, el Ministerio Fiscal nos reconoce que ha sido precisamente la declaración.
Mr. Aldama's actions are what have led to the creation of a crucial file regarding public works and the illegal awarding of public works contracts.
Handwritten documents by Mr. Koldo were submitted to the case.
It has been proven by expert analysis, despite the government's and Mr. Koldo Garcia's claims that we were lying. When we stated that it was Mr. Koldo Garcia's handwriting, it has been proven by expert analysis that it was indeed his handwriting.
And everything has been proven when it was said that we couldn't provide more evidence. What is required from a citizen when facing a system, what more can be done? To tell the truth, for that truth to be corroborated, for it to open lines of investigation, and for it to be the police who ultimately confirm it. The government says, where is the evidence from Aldama? Read it. It seems that the June 2025 report hasn't been read. What does it confirm? It fully corroborates what Mr. Aldama already said in 2024. Mr. Aldama is being called a criminal by the state, by the government. Mr. Santos Cerdan is not mentioned. There is no mention of No other member of the government is mentioned. No presidents of autonomous communities are mentioned. Only Mr. Aldama is mentioned. Mr. Aldama has cooperated with the justice system. He has cooperated by providing truthful information, supplementing the UCO reports, adding substance to the UCO reports, and allowing the interpretation of certain conversations.
Opening up new lines of investigation for us that have revealed the existence of much more serious events than those that were initially under investigation.
At the moment when Mr. Aldama provides that cooperation, other members of the government have been identified. Santos, Cerdan, Leon. The first person to mention him was Mr. Aldama.
Let's not forget this. It's easy now to go to the UCO and say, we found evidence. Of course, after the investigative leads had already been laid out, afterward. Of course, when the devices are opened 6 months later, it is verified that what Mr. Aldama said about the Basque quota was real, that the documents Mr. Aldama already handed over, marking the public works with colors,
were real, that the contractor companies he mentioned, specifically Levantina,
And what about Mr. Russ's role?
who in the end has also been proven to be one of the Aldamas in the investigation, was real and was pointed out by Mr. Aldama.
Where is Mr. Aldama's evidence? We believe we have provided them clearly. Mr. Carlos Moreno, Minister Montero places special emphasis on discrediting Mr. Aldama. Sir, from the initial denial by Mr. Carlos Moreno, which has been established throughout the case, the issue of splitting the debt is, in the end, merely incidental. In a conversation on April 9, they even talk about handing over 300,000 euros in cash.
But Mr. Carlos Moreno has had to end up admitting here today as a witness that his meetings with Mr. Aldama took place at Ciudad Real Airport.
The sale of the Ministry of Finance building on Maria de Molina Street.
The efforts of an Israeli gentleman for the VAT refund who was looking for an apartment, and of course the tax debt was postponed.
Where is the evidence from the Chief of Staff of the Minister of Finance? The audio we heard the other day is sufficient. Suficiente. The first time Mr. Carlos Moreno is mentioned in this case is by Mr. Víctor de Aldama, in a case whose subject was very limited.
We insist.
The scale of the organization on trial today was revealed by Mr. Aldama, opening up lines of investigation.
This requires, and I will finish briefly, it requires a response from this honorable court.
There has been talk of encouraging, of restoring trust in the institutions. Of course, the crime is committed from within the institutions, but Mr. Aldama does not hold any constitutional or institutional position.
Mr. Abalos does, and Mr. Koldo also perform public duties.
The institutions are not Mr. Aldama. The institutions are the high-ranking officials of the government of Spain. It's not Mr. Aldama. He's being portrayed here as if he were responsible for an organization that, as the UCO acknowledges, was already fully established when Mr. Aldama was recruited. He has acknowledged the facts. He has admitted to the crimes. He has admitted to being used as an instrument to finance, either personally or even organizationally, the Socialist Party or high-ranking government officials. It's commendable for a citizen to decide to take that step. Certainly, it can be said he does it when he has already been detained or when he was already under investigation. That's why I said that if the court does not consider that the requirement of a voluntary departure from the organization is met, in any case, the same rationale exists for applying it by analogy. This is not just a simple confession as a mitigating factor, nor even active collaboration, nor is it just a version that corroborates the existing evidence. New facts have been provided. New facts about bribery that were previously unknown. We have acknowledged that we have paid for more things, not just the 10,000 euros we have provided context. We, the Public Prosecutor's Office, appreciate the mention. And that has been done precisely in accordance with the new guidelines of international policy, specifically regarding the fight against corruption, terrorism, and drug trafficking. That was already understood. The important thing is the fight against corruption. And what's important is precisely the incentive. The incentive that the citizen who helps dismantle the organization receives to discover new members of the organization and to prevent its evolution and development. Mr. Aldama has identified new members of an organization that were completely unknown to the police investigation at the time he made his contribution. For this reason, the requirements that we consider necessary to apply Article 574 of the Criminal Procedure Law are met. Specifically, it is a special provision for collaboration with the organization. The legislator has introduced the phrase voluntary abandonment as if to mean that if the collaboration comes late, then perhaps the mitigation can be a factor to consider for 1 or 2 degrees. But the framework decision on which this provision is based from 2008 of the Council of October 24, 2008, it's enough that it says they can be reduced or even not applied, mind you. The prosecution service has pointed out how for the offense of rigging public tenders, even the legislator has opted for an exemption for those who actively collaborate in dismantling the organization. I'm finishing, believe me. But in this framework decision from which Article 570 bis quarter originates, it even talks about not being applied and of course about being reduced. And it doesn't require any timing requirement. Any post-offense conduct logically implies a reaffirmation of the rule considered violated and in some way an expression of repentance in some way by the person who has previously committed a crime. But it is enough to provide the authorities with information that helps them identify or prosecute other perpetrators of the crime, which is what has happened here. If the court had the full scope of the case, Mr. Aldama has identified other members who committed the crimes, has helped to find evidence, has contributed. We have documented an important set of documents that can be evaluated by the court. Of course, he has put an end to his criminal contribution and has titanically begun active cooperation with the authorities, offering to collaborate in many cases and incriminating himself in acts that, until that moment, he was not being incriminated for. He has been summoned recently in a few days on the 14th, also as responsible with respect to the governments of the Canary Islands and the Balearic Islands. He is also under investigation for the award of public works contracts. These are facts that were not known before Mr. de Aldama's statement was made. In any case, this type of privilege applies not only to the situation, even by analogy, because of the importance or intensity of their collaboration, and of course confession as a mitigating factor, which in our view should carry special weight. We are aware of the court's jurisprudence, we do not ignore it. That analogy already prevents it from being further reduced and considered highly qualified. The intensity of the collaboration must be assessed. We believe that this intensity, the one required of Mr. Aldama, has been met to an extraordinary degree. He has gone far beyond what was required. A confession, an acknowledgement would have been enough. We are used to the fact that at the courthouse doors before trial, plea agreements are even entered into that involve a substantial reduction of sentences, and the prosecution accepts it. Here, for whatever reasons, it hasn't been signed. But of course, the importance of the collaboration has not only been highlighted by the Public Prosecutor's Office, but I think it's only fair to acknowledge it. His contribution merits special weight, not only to encourage and incentivize precisely those behaviors as international legislation intends. The government's own plan for 2025, the draft criminal procedure law for 2025 itself, aims to promote precisely this type of behavior. It has to be an incentive, because if it's not an incentive, as the prosecution rightly acknowledged this morning, the law of silence would prevail. If collaborating really doesn't benefit you personally, if self-incrimination of new facts is like shooting yourself in the foot. And then, in the end, if all I get is more charges added to my record, what sense does it make to cooperate with the state? We're not talking about the seriousness of the crimes. The seriousness is determined within the statutory sentencing framework. Here, what we're talking about is whether public interest reasons of assisting the administration of justice, of helping this court to establish a fact with certainty or greater certainty, deserve to be rewarded.
If, in addition, that cooperation is carried out alone by a citizen against a state apparatus in which a criminal organization was already in place before he arrived and which has recruited him,
I think the merit is much greater. Or precisely to set a precedent regarding this situation, it's difficult to have a subjective criterion, the greater or lesser intensity of the cooperation. It's a matter of judgment.
of the sovereign judgment of this court. We can all have an opinion. The public can have an opinion. Members of the government can have an opinion. But in the end, it's a decision that this court has to make, because determining the sentence is one of the essential functions of the court,
Of the power to judge. And that is a sovereign decision based on all the circumstances that have been proven here. Therefore,
we have acknowledged the facts, we have acknowledged the prosecution's legal characterization, and the only thing we have disagreed on. Although certainly the prosecution has acknowledged to us that there is more than one legal option, in fact, it is common. It is also common to agree to a reduction of 1 or 2 degrees,
which is what, in the opinion of the court, will have to be established. And that is what this party is requesting.
and throughout the entire process, I have limited my defense to that, to emphasizing the statement of Mr. Aldama, to corroborating its complete accuracy, and to highlighting the importance of this collaboration. Nothing more. Thank you very much. And once again, I appreciate the honor of always appearing before this High Court.
Thank you very much. The trial is suspended until 4 in the afternoon.